So the Constitution, as it currently stands, does two things. The first thing that it does is to protect existing property rights from arbitrary state influences against the payment of just and equitable compensation. And the second thing that the current property clause does is to allow access to land on an equitable basis, and that's through land reform. And at the moment, there are three tenets of land reform, namely land redistribution, and also security of tenure, and also land restitution, which refers to groups or individuals who lost land as a result of racially discriminatory laws before 19 June 1913. So in terms of the first part of the Constitution, which is the protection of existing property rights, whenever the state or any individual interferes with property rights, then depending on the nature of that particular interference, compensation has to be paid for that particular expropriation. And in calculating expropriation, there are a number of factors which are taken into account, of which market value is but one of the factors. The other factors that need to be taken into account are things such as the history of the property, the manner in which that property was obtained, as well as the extent of direct state subsidies in that property. So this reading of the Constitution suggests that compensation need not be at market value. But because at the moment we are still using the Expropriation Act of from 1975, we are very much in a situation where the legal culture pertaining to expropriation is out of sync with the Constitution. And this is what creates the impression that land reform at the current pace is simply unaffordable by the state. And it's for this reason that one would argue that there is no need to amend the Constitution in order to effect expropriation without compensation. I think we need to look at the factors on the ground, namely the fact that we have an Expropriation Act which predates the Constitution, and as such is out of sync with the Constitution in that it demands that payment be made at market value, and it also doesn't allow for a lot of procedural requirements such as just an administrative action, which the Constitution currently provides for. Apart from the fact that if one considers the report that was released in early 2018, the high-level panel report, which was commissioned by former President Kgalema Motlanthe, it's quite obvious where the failings of land reform lie. So, for example, with land redistribution, we do not have a singular piece of law which governs how exactly land redistribution is to be governed. And if you consider tenure, the fact that we have so many different policies, some of which are in conflict with each other, mean that at the end of the day, there is a lot of insecure tenure. So what is needed going forward is to, first of all, come up with an Expropriation Act which properly reflects the Constitution, and secondly, fix the problems that are identified in the high-level panel report. It stands to reason that even if expropriation without compensation is effected, if we do not fix the problems of land reform which have been identified by the high-level panel report, we are simply going to be back at square one, and there isn't going to be a proper effect of land reform as envisaged by the Constitution.